Lucas Walker, this is a thrill.
Oh, pleasure to be here.
Yeah. So, a Falconer native, what does that really mean? Where were you born specifically?
I was actually born in Montana.
Oh, really?
Yeah,
Okay.
accidentally.
Okay.
So I grew up in Falconer, outside of Falconer, between Falconer and Kennedy. But my parents were dairy farmers, and when they were expecting me, they were invited to a young farmers convention in Bozeman, Montana. And as the story goes, the doctor said, "There's no way that kid will be born in Montana. Go ahead." 11 hours after they touched down, there I am.
No kidding.
So my first whole week of life was spent in Montana.
Yeah. Oh my gosh, that's fast. I think what your mother's reaction was like, "You got to be kidding me."
Yeah, it's like, we don't have anything here.
Yeah, yeah.
But very generous, welcoming people there, both at the convention and just in the town. So they were well taken care of.
Yeah.
So.
Tell me a little bit about your mom and dad.
So my dad's Mike Walker. He was a dairy farmer for a long time. He's retired from the dairy business, but still keeps himself busy. He actually does cattle photography a lot now, taking pictures of show cows. And so he's a Falconer native, went to Falconer High School, and grew up on the same dairy farm outside of Falconer that I grew up on. And
A little bit about your mom?
yeah, my mom's originally from Nebraska. She grew up on a dairy, beef, pig, chicken farm out there. Came out here for the Cornell Cooperative Extension. She was the extension agent back in the early 70s, or late 70s, and met my dad through that, and ended up becoming a teacher later on. So she taught at Randolph for, I think about 20 years, teaching agriculture and later physics.
What about going way back, Grandpa? Is this family farming? Was that your dad's business, or his father's business?
Yeah. I think it goes as far back as my dad's dad's dad. So my great grandfather. I think they had lived in Westfield for a while, and then
Right.
I think came to Falconer, maybe came back to Falconer. I think they had previously been there. So it was Frank S. Walker, and then Frank L. Walker, then Mike Walker, and then rolled things up and sold the farm some years ago.
So there was no pressure for you to continue the farming because you'd kind of wrap that up?
Yeah, there was never any pressure, and that was one great thing, is that we were, my brother, my sister, and I were all completely free and encouraged to do what we wanted to do, not to just follow in the farm or anything like that. So my sister lives on a farm. Her husband's a dairy farmer in central New York. My brother is a radiologist in Omaha, doctor, and I'm a lawyer practicing in D.C.
Good. They got to be so proud.
I think so.
Going to school, because of where you lived, would have been Falconer, right?
Yep.
And was there areas within which you kind of gravitated towards as a student?
Oh, I loved it all, to be completely honest. I love social studies and history, probably most, which is what led me down to the law path. But I loved science. I loved English. I wasn't very good at Spanish, but I liked that too. So I really enjoyed it all, but I think the history of social studies, government kind of angle of it was always what was most drawn to. And that's kind of, I think, what led me in the direction of the law.
So, was there a teacher or two that, because I've had many come up and say, "Oh, that Lucas, he's something else." But was there one or two that sort of were role models for you?
Oh gosh, so I worry about saying any names because I'd be leaving out a lot of people who played a big role and are deserving too. So I will, with the important qualification that this is willfully incomplete, I will say Kitty Shalino, our kindergarten teacher, I think set all three of us, my brother, my sister, and I, on the right path.
Mm-hmm.
I think Bill and C.K. Hennon. Mr. Hennon was the social studies government teacher. Mrs. Hennon was a Spanish teacher and the coach for our radio quiz team. Great role models and supporters, and I think, helped lead down that government path. Michelle Black, science teacher, great friend, to this day, my sponsor for my confirmation, actually.
Sure.
And I'll say Bill Kilmartin to our physics and biology teacher. I think that's not nearly all of them. There are others, but those are some that, and actually Michelle Johnson too, our business teacher and the advisor for our FBLA, Future Business Leaders of America program, which I think is something that helped me to get a little bit more out of my shell in high school and take up on some leadership roles as well. So I apologize to anyone that I'm missing. There's a lot of others to thank, but those are a few would come to mind.
Yeah. So noted. Now, did you think yourself as somewhat of an introverted kid?
Yeah, I think on the whole, I'm probably still an introvert. I was the kid who would go to a football game when I was in elementary school, and I would probably have brought a book to read in the stands. That's probably not anything I would do now, but I was known for reading the encyclopedia as a kid, so I think that kind of goes along with the bookworm introverted.
Did Future talk about, not I'm sure everybody might watch this, and I'm sure there many will, the Future Leaders Program, talk about that, because I'm not even sure we even had that at Jamestown.
Yeah, Future Business Leaders of America. It's it's kind of designed to get people to be in leadership roles in business, but business is really broad. It's kind of like any organization that needs people to manage it, to lead it, to inspire it some way down the way.
Right.
I wasn't doing any inspiring in high school, but and it has a bunch of different competitions and a lot of kind of really fundamental areas of business. I did economics and accounting and entrepreneurship and business marketing. I think were just a few of the ones I can remember doing. They do impromptu speaking to get, they give someone a topic and you have to speak about it with just a few minutes of preparation. And so like a lot of these skills that are, it's good to build those muscles early on.
As you're going through high school and going through this phase, your own self-confidence building phase, was there an aha moment where I said, I think I can project myself maybe in a more of a leadership role? Was there a time, an event?
I'm not sure there was any real aha moment. I think I tried that pretty early on. Run for like student council president, did not get it. In middle school, ran for student council president, and senior high did not get it. But I think one thing that was probably the one place that I was like, the leader of something was when I was the captain of our high school bowl team, our radio quiz team, as a senior, and it felt like that was something where it was a good feeling to be able to kind of be the person that folks could rally around or something like that. So I always tried to offer good ideas when I can, but I was not usually the one right at most at the forefront.
So, and I don't want to dwell in your total high school career, but the high school quiz program of Dennis Webster, WJTN, and he's just announced that I think he's not going to continue that.
Oh, really?
That doesn't mean the program's not going to continue, but he will not continue it.
Oh.
How do you prepare for that? I mean, you're the captain of the team, and it gets a lot of publicity, and it's as well, and all the schools participate. But I'm thinking, how do you say here's topics we got to look at, current topics? How do you prep?
I read a lot. That's when all that reading that encyclopedia when I was a younger kid came in handy, and if you could dredge some of that stuff up. And then just kind of drills. We had a lot of flashcards with a lot of questions on it to prepare, just like if we were at the the matches, and so we'd meet every week, and we'd go through those, and try and play to our strengths. So it's a team game. So someone might be better at the music questions. I could never tell you how many notes are in a scale or anything. Well, I think there's 7 notes in a scale, but in the different kinds of musical scales. Or others might be better at the math parts where you have to do math real quick. And so I think it was, finding out what works for a particular person, where can we develop that, and we can all contribute.
And the way it's set up is it's 2 schools, and Dennis asks the questions, back and forth, and that's how it works, right?
Mm-hmm. Yep. Buzz in. They ask a toss-up question. You buzz in. The first one to get in gets a chance to answer it, and if you get it right, then you get a bonus question for a few extra points as well. That's just for your team. And on those ones, you can confer with your teammates as well.
Where's it held?
It's at JCC. It was in, I think it was in one of the library buildings back when we did it. I think it's moved probably to a different couple spots since then.
That's terrific.
Yeah, and I'm sorry to hear that Denny's stepping down. I guess well deserved. He's been an institution with that.
I don't. Who does the? Is it a national system who actually creates the questions, or?
I think each of the schools kind of prepares questions and submits them, because I remember our writing questions for that, and I'm sure they're all screened and all of that. But,
Fantastic. How'd you do?
We won the county. I guess it's even broader than the county, but we won the high school bowl championship my junior and my senior years.
There.
Yeah.
Fantastic.
Yeah.
So all of a sudden, high school graduation. We've just had commencements all over the county.
Mm-hmm.
And you had to start thinking of your next step. Did you have advisors, or did you have a sense yourself as to what it is that you might want to do?
Yeah. So Tina DeLiba was my guidance counselor for those last couple of years, and she was really supportive. And along with all the teachers that I mentioned, my parents as well, and kind of figuring out what I wanted to do. And I can't say that there was any real great rhyme or reason or plan to anything that I wanted to do. And I should say, most importantly, the best thing that came out of high school for me was that I met my wife. Jetta Fosberg, now Jetta Walker, who's, we got together senior year, and so incredibly supportive of as well.
Well, let's talk about that. How'd that happen?
I got really lucky. She transferred to Falconer in 9th grade. She had gone to Jamestown before that, and we just got to know each other. I think first in gym class, the very first time. A year or two later, we sat next to each other in our global studies class, and we had some mutual friends. And it took a while, but finally, our senior year, just around homecoming, we got together.
Well, tell me about her mom and dad. Was her dad Frosty?
Fozzie?
Fozzie,
Yeah, Mark Fosberg. He went to Jamestown. I think he might have been in your class, or a year before or after you. Yeah. So, and her mom's Janice Fosberg. So they still live in Jamestown. Her brother Marcus and his wife Jessica are Jamestown as well.
No, they stumble across Mark every once in a while, and he's very proud, very proud. But you still had to decide kind of not only where you might go, but was the college you went to your first choice?
Yeah. I think for a while I went to Yale, and I think for a while it had always kind of been in the back of the mind, and then maybe a little more in the front of my mind as kind of like the place that I wanted to go. And I'm not, obviously, great school, great reputation. I think the very first spark was just I thought the name was cool.
Yeah.
But I think that was always to the extent there. Once I started thinking about that kind of thing, that was always really the dream. I have an aunt who lives in Connecticut, near New Haven, where the school is. And so we'd gotten a chance to, kind of visit a little early on. And, so that's really what I kind of aspired to. And lightning struck, and I got to go there. I still remember it was a weekend when the letters came out. I think they might have done it by email by then, but I wasn't checking email 50 times a day. Back in those days. And I was having breakfast Saturday morning, and the table, and my mom had gone down to get the mail and throws the big fat envelope in front of me as I'm eating my cereal.
Wow, well, that's such an honor in that Ivy League type schools, any place, any time, but let alone, find yourself in that position. And so it was a yes, instant yes?
Pretty much, yeah. I went to Bulldog Days, that's what they call it, for the admitted students to spend some time on campus and get a feel for it. So I think I probably went to that before I sent in my acceptance, but there was really no question that I was gonna accept it.
Early on, when you get to Yale, do you have to kind of commit yourself as to your studies, or is that something you declare like your junior year, your major and stuff like that?
Yeah. The junior year is when you have to decide a major. And so freshman year for a lot of people is really just kind of exploring, trying a lot of different stuff that they might not have had a chance to do in high school and they might never pursue, but they can get a feel for it. So I had a pretty good sense that I wanted to do something in kind of history, political science, law. I mean, they don't have a pre-law major, but there's, kind of classes that are in that vein. And so I took a couple of classes on American history my first semester, but I also took an astronomy class. I always loved astronomy, but never taken a real class in it. So,
is that a required kind of a distribution?
There is a little bit, yeah. So you have to, there's 4, I can't remember exactly what they are, but there's, like math and science, social science, history. There's one that, that the languages fall into, and I'm sure there's a 4th one. I don't remember exactly how they split them all down, but the idea is you have to get at least a certain number of credits in each of them, just to ensure that you are in some way kind of a well-rounded person when you're coming out of the school.
Where was the moment where you said, I really got to get into pre-law with an eye towards taking the LSATs, and was there a junior year? Was that the moment where you said, going for it?
Yeah, I think the moment that stands out most in my mind was from my sophomore year. I was taking a class on American legal history, and we were reading this case from the 1800s. It was the Charles River Bridge case, I remember. And it was basically, one company had been given a kind of the license or the monopoly on operating a ferry across a particular place on the Charles River, which is by Boston. And the question was whether that prevented someone else from being able to build a bridge over that same spot. And so there was a big debate again between, I think it was Chief Justice Taney at that time, so it was probably in the 1830s, and Joseph Story, who was the youngest Supreme Court justice ever appointed, age of 32, and was there for, I think, about 30 years, and a real big figure in the early constitutional, legal history of America. And so Taney wrote the opinion for the court. Justice Story wrote the dissent, and there was this debate over how should we view this kind of monopoly. And Justice Taney had kind of it was the very practical. It's like, well, we shouldn't view this as preventing progress and being able to build a bridge that would be better than just taking people across on a ferry. And that made an awful lot of sense until you read Justice Story's dissent, which I think I kind of agreed with then, and maybe even today as well, that may be all well and good, and maybe we do want those sorts of things, but when someone was given a monopoly, he said, the law had always understood that to be it was exclusive, and you couldn't have someone else come in there, and so, basically they had a contract, and you had to respect, the rights they'd gotten under that, and there was, you could use eminent domain or something if you wanted to, still wanted to build that bridge, but, that you had to respect what this was, what this right was understood to bring with it when it was granted. So, but I just remember getting into that and writing a critique of the majority opinion. It's like, this is something I need to be able to do a lot more often.
Yeah.
So.
Oh, interesting. So that was sort of your guide star, that time period, sophomore class, reading, and just sort of thinking, well, let's see if I can take it steps further.
Yeah, I think that was the point where it seemed more likely than not, trending toward like overwhelmingly likely that I was going to be looking to go to law school.
Yeah. When it came time, you graduate, what year did you graduate from Yale?
2006.
2006. Now you got to make some decisions where to apply, and what was your list look like?
It was broader than when I was applying to college, and I decided not to apply to Yale Law School for two reasons. One, I was pretty sure I wouldn't get in, and that would sting. And secondly, I just felt like I'd spent a lot of time on that campus, and I'll try something else. So I applied to about 6 schools, and schools you'd kind of expect people to apply to, and I got into half of them. I actually got waitlisted at 3 of them, got into 3 of them, but one of the ones that let me in was Harvard, and I think that was my top choice to go to, and that was another easy yes once they gave me the offer.
So you go to Harvard, and it being 3 years for those who are not familiar with that world, was there, again, a gravitation within the law school as the subject matter which caught your attention? Was it constitutional law?
Yeah, I really liked kind of I'll say the sort of the hardcore of law subject. They're not necessarily hardest in terms of difficulty, but like the ones you sort of think of as the core of very classical law. So constitutional law, administrative law, federal agencies and the laws that govern them. Federal courts and jurisdiction, which gets really intricate real fast in terms of when can you bring a suit in federal court, how do federal courts deal with it, all these really interesting and often very gnarly and obscure doctrines that govern how cases are litigated there. So I loaded up on a whole bunch of cases, courses like that: separation of powers, federalism, the First Amendment, the 14th Amendment, which governs a lot of individual rights. So I had an awful lot of those. Those were the topics I was most interested in. So I went as deep as I could.
Were there teachers or two that sort of were either of note to you that you found most inspiration from?
I would say the law school teacher who absolutely most inspired and meant the most to me was Dan Meltzer. He's since passed a few years ago, but a longtime fixture at the at Harvard Law School, one of the assistant deans. There's actually a brick for his father, Bernard Meltzer, who was a longtime professor at the University of Chicago, out in front of the Jackson Center here. But he was the leader of my section. So at Harvard and in a lot of law schools, the first year students are divided into different smaller sections. So you've got a group, I think it was 7 sections of 80 students each. So it's 80 students that have the same set of first year professors. And so Professor Meltzer was the leader of section 2, and taught criminal law, which was one of my favorite classes, both the kind of the different degrees of murder and assault and the different kinds of crimes that are out there, and also criminal procedure, the Fourth Amendment, search and seizure kind of stuff. When can the police arrest you? When can they search your house, your car, and things like that. And then I later had him the next year for federal courts, which was, I think, my all-time favorite class in law school. And he was one of the authors on the case book for that, which is Hart and Wexler's Federal Courts, which is famous among law nerds for being a really difficult, really thorough, really comprehensive classic textbook on federal courts. And so I just loved it. He was a great professor. I'm so sorry we lost him, but he both of those classes, and then he was kind enough to write a letter of recommendation for me when I was applying to clerkships.
Sitting right there, many moons ago in 2001 was Bernie Meltzer. So I did an interview with him. So it's just kind of ironic. So if you feel the vibes, it's there. And what a wonderfully smart guy. Barney Meltzer. You read about some of your Harvard con law professors who are more public. I mean, they're out there. And did your paths cross with any of those guys?
So one who I think has done the Jackson lecture at Chautauqua and probably been here as well, Akil Amar.
Yep.
So one of the more prominent kind of public intellectual
Right.
constitutional lawyers, has written a lot of books, not just articles, so broader audience, more accessible in a lot of ways. So I actually took a class with him in law school about just constitutional law. I think
Right.
it was what it was. So it was a really broad survey of constitutional law. And then he happened also to be visiting at Harvard my 3L, my final year there at the law school. So I took a class with him there as well, which was kind of reading the Constitution, getting really deep into what the
Right.
text of the Constitution is. And so we had some good conversations about the 11th Amendment, which deals with when you can sue states in federal court. That was probably the biggest name, at least the one that's coming to mind. He was also very helpful. Turned out that I got hired by a judge for a clerkship who ended up leaving the bench before I graduated, and so before I started with him.
Right.
Professor Amar was very helpful there too, in helping to navigate that situation.
Well, let's talk about that. I mean, you graduate.
Yep.
And you graduated in 2009,
Yes.
so from Harvard. And at that point, you have choices. Most people do, of whether you go into the public sector as a clerk or whether you want to go into the private sector, because there are always opportunities to go there as well. Tell me about that decision, the kind of clerkship, private.
Yeah, so it was easy. It was maybe not even a real decision. It was just, I always felt like once I kind of understood what clerkships were, which is you get to spend a year with a federal judge, helping them decide cases, at least giving your best opinion on it, and then they'll decide the case the way they think is right, but helping to draft opinions and getting to just work really closely and see close up how they decide cases and think about the law. And so, it's a one-year commitment, so there's lots of things you can do after that, and so it was a real easy call to try for that. It's competitive, there's no guarantee you're going to get it, but I think pretty early on, once I realized it was a possibility, that I was going to pursue it.
So you get the recommendations from Dan Meltzer, you get your resume put together, and you'd say, how do you enter the system?
Well, so it's changed a lot over the years, although in some ways it's similar, in some ways it's not. There used to be a thing called the clerkship plan, the plan they'd call it, which is basically a lot of judges, but not all of the judges agreed, we won't accept, or at least we won't look at applications before this date. We won't schedule interviews before this time on this day. We won't actually have the interviews until this time. So the idea is you don't have judges who are hiring really early so that law students feel a lot of pressure to, apply to those or accept offers if they haven't had a chance to maybe interview with other judges. It's fallen apart a couple of times. They tried to revive it. I don't think it exists anymore in terms of that timing. But it existed back when I was applying, and I decided that's what I'm going to do. I'm just going to apply on the plan, so I'll get all my materials in. At the time, the other nice thing is I was getting married that summer that all the stuff was done, so having everything due just a little bit after that and not having to worry about it while we were preparing for the wedding I think was a good move. But so I submitted, uploaded everything. There's just a website, it's called OSCAR, which stands for something, some clever acronym, but I don't remember what it is. And so submitted that, and the professors would submit their recommendation letters, and then at some point it gets released out to all of the judges, and then I think it was at noon on some designated day, they were allowed to start calling to interview, to schedule
No kidding.
interviews.
So and to that extent, it's random. I mean, you just almost visualize that you're putting into Oscar this pile of information. It is submitted to all federal courts.
So you could do that. I applied to about 30 federal court of appeals judges.
Okay, so was there like a checklist?
Yeah, you choose which ones you want to have it submitted
see.
to, and
Okay.
you could theoretically, I think you could submit to every judge who accepts them through Oscar. There are hundreds of them, and I did about 30 some Court of Appeals judges. I always was most interested in appellate law, and so I wanted to try for a Court of Appeals clerkship. That's
And then
what I
you
focused on.
got a call.
I did, yeah. I got a few calls. I was lucky with that, and funnily enough, I got 2 calls almost right at the same time. One with a judge who is on the 10th Circuit in Salt Lake City, Michael McConnell, well-known constitutional law scholar. He's now at Stanford, and with Judge Colleton, who's on the 8th Circuit in Des Moines. It was like right at the same time. I think I was on the phone with one of their chambers. Obviously, the judges are not making the calls to schedule the interviews. And I got a voicemail message from the other one. And they were so kind and generous in accommodating it. So sometimes you hear stories of judges having sharp elbows and competing for clerk candidates. Seems a little silly. They're law students. There's lots of them to choose from. But they arranged it so I was able to interview with Judge McConnell from over the phone from an empty visiting judge's chambers in the same courthouse where I was then going to an interview with Judge Colleton, which I thought was a real credit to the two of them, that they were so accommodating and didn't kind of force me to choose between which one that I wanted to go for, because they were 2 of my very top picks.
Which one did you pick?
So I ended up going with Judge McConnell. He extended me, and so I interviewed with him, met with Judge Colleton, and then called Judge McConnell back. He extended me an offer, but I mean, both his reputation is phenomenal. But he was in Utah, Salt Lake City, and those Montana roots.
Sure, you're almost in,
Spending a year in the mountains was another big plus in itself as well.
You're young, married, no kids yet? So,
Not at that point, no.
yeah. So off you go for that first year?
Well, I was going to.
Oh, that's right.
Yeah, I was going to. And then just a little bit before I graduated, Judge McConnell calls me and says, just so you know, I've decided to leave the bench and head up the Constitutional Law Center at Stanford, longtime law professor, well-known scholar. And so you could tell that was really ultimately what he felt was his calling. But it meant that I was a month from graduating law school, and I didn't know what I was going to be doing next. But he was tremendously helpful in helping to navigate that and making sure that I and all of my co-clerks to be former future co-clerks were all well taken care of. And so I kind of still wanted to clerk on the 10th Circuit, which covers a bunch of states in the Mountain West, so Colorado, Wyoming, Utah, New Mexico, Oklahoma, and Kansas, just to name them all. And so I had a friend who was clerking for a different judge, also on the 10th Circuit that same year, who had just been appointed about 3 years before that. And it's like, maybe this would be a good fit. And so Judge McConnell was able to introduce me to one of their new judges named Neil Gorsuch.
I heard of him.
Yeah.
How interesting.
Yeah.
So you work for the Court of Appeals, Federal Court of Appeals Judge Gorsuch, first year.
Yeah.
What was your impression of him?
Tremendously smart, tremendously warm, kind, a great mentor for all of his clerks, both during the clerkship and afterward. It is a real clerkship family where we stay in touch with each other, stay in touch with the judge, now the justice, and just incredibly smart. He was appointed to the bench very young. He was about 38, but just the depth of his knowledge, experience, and skill. Great writer, really distinctive style. I'm still developing a lot of those things, but he, had all very fully formed right from there. And so that was a wonderful year, that clerkship.
So the clerkships consist of 4 clerks?
Yes, yeah. So typically each Court of Appeals judge has 4 clerks. But because of my unusual situation where I was kind of an adopted clerk, we had 5 that year.
How does how does one convey, because you hear the term, a judge has his own style of writing. How do you can't even really teach it in a sense other than, here, read it. Read a bunch of my stuff and you'll get a sense of how I write.
Yeah, a little bit. I think he would describe it as it should be conversational. You should try and write the way that you would speak about something, in a like a public setting or something like that, not too casually, but to make it accessible to the reader. Always keep your reader in mind, your audience in mind, whether it's the parties or the public who are reading a judicial opinion, or when you're on the side of things that I am now, you're a lawyer and you're writing a brief for a judicial audience. And you always want to keep in mind, what is going to make it easiest for them to understand what I'm saying and to be persuaded by what I'm arguing to them. Yeah, and then, and I think, we did our best to kind of capture that style that he had, but I'm sure he would say he cares a lot more about the clerks getting things right, get the record right, know the law, put it together, and he can make it sound like him.
Yeah.
But we did have fun trying to capture that.
And during that year, do you remember a case or two that sort of were like, wow, this is, how do these issues actually come to be? I mean, where it's just unique. Yeah,
well, so I guess with the important caveat that we're not really supposed to talk about cases that we worked on.
Understood.
And so there are a couple of cases, and I can, without saying whether I worked on either of them, that did really feel like it was the 10th Circuit, that mountain circuit. And one involved rules over snowmobiles in Yellowstone National Park, where different courts across the country, so the National Park Service had issued a rule saying you can let in this many snowmobiles this year. And so you'd have one district court in Wyoming that says that's not enough snowmobiles, and you had a different one in the District of Columbia saying that's too many snowmobiles. And they kept kind of going back and forth and trying to figure it out. And it finally came to a place where the DC court, I think, had said it was striking down a rule that let in a certain number of snowmobiles, and the Wyoming court says, all right, I'm not going to say anything about that, but now we have to figure out how many snowmobiles come in. So we're going to go back to the old rule, and it actually lets in more snowmobiles. So it was a really weird situation. You could get a sense of different courts in different parts of the country are going to maybe have different views of these things, about how many are snowmobiles in Yellowstone a good thing, or are they really something to be kept to a minimum? But when it came up to the 10th Circuit, it really ended up, the court held the whole thing was moot because the National Park Service adopted yet another rule, and that was going to say how many snowmobiles were. Yeah. But I remember that it was just something that it was the very first sitting, so that the court has a sitting where they hear, I don't know, some number of cases over the course of a week. Every other month in the 10th Circuit. So there was probably, 12 cases or something like that, that my co-clerks and I were, helping the judge with that. And that was one of the very first ones. I think that's why it really stuck in my mind as well. Yeah. Mechanically, did you listen to the arguments? Did you go in? Yeah. Certainly for any case that we were the assigned clerk to, but really as many cases as we could, as long as we didn't, have some urgent deadline on some project, we would go and watch all of the arguments and get to see the counsel, get a sense of, what works, what doesn't work, see the judges in action, because they sit in random panels of 3. So by going to a lot of those different sittings, you get a chance to see pretty much all of the different judges on the court sitting with our judge, Judge Gorsuch. So then there's, because it's not in banc, in total, where all of the judges sit most of the time, that's not a normal thing, it's just 3, right? Yeah, typically 3. I think it's 12 active judges total on the 10th Circuit, and then 3 of them, which might include some senior judges or some other judges from elsewhere who sit by designation. Yeah. They call it visiting judges. Hear most of the cases, but we did have some en banc cases where the entire 12-judge court sat to hear cases, and that was another one that I really remember Judge Gorsuch ended up writing the majority opinion, but it dealt with the definition of Indian country as it was relevant to where you needed to get a permit from for, I think it dealt with maybe uranium mining or something like that, but dealing with safe water issues. And so that was one where I think 11 judges sat on that, and it divided 6-5. So,
Wow.
yeah.
Do the judges in turn, I know that they at some point vote, in privacy without, clerks or anybody else in session, but does Justice Gorsuch at this point, Judge Gorsuch rather, does he gather the clerks together saying, you guys heard what I heard, and give a kind of a direction, an opinion, or ask for comment?
Yeah, we would usually talk about the cases after the argument and give, what our views were, and, he might, well, so usually the judges would meet immediately after argument to conference and give their tentative votes on how to decide the cases. So usually, by the time we reconvened and we gave our views, he would have a sense of where he was coming out and where the other panel members were coming out. So that was always a fun part of it to figure out where it was all going to go. Sometimes it wasn't what you expected just from reading the briefs.
Yeah. Did you know internally what you were the clerk assigned to that case before or after?
Yeah. So we would get, I don't know, a month or so in advance of actually hearing the case. We'd get the briefs and all the cases that we were going to hear during that session, and so we, the clerks, would split them up among ourselves in a way that we, felt was roughly fair based on.
Was there a staff person that did that? Or did you, among the five of you, decide, I'd like that one, I'd like that one?
Yeah. So we the clerks ourselves decided which ones we would take. Although I would say Holly Cody was Judge Gorsuch's judicial assistant out on the 10th Circuit, and what a lovely person. Love Holly so much. But thankfully, she never had to bring down the hammer and say, "You're taking this case. You're taking this case. You're taking this case."
Worked it out. That year, because it's a year contract, you're an add-on, the fifth of what normally 4. Then was there a sense what you would want to do next?
Well, the funny thing is, so I had been a summer associate at a law firm called Gibson Dunn in D.C. the summer before my last year of law school. And so I had planned they'd made me an offer to join them after my clerkship, and I had planned to take that. But it was, by happenstance, the week after my clerkship finished, we were still in Colorado for a little bit, and there the bench and bar conference, basically the judges of the 10th Circuit and the lawyers who practice in the 10th Circuit. There was a conference on Colorado Springs, and I was like, all right, I'll go down. I don't have any responsibilities anymore, but it would be good to see my co-clerks, some of them were still with the judge, and just see what that's about. So I went down and I ran into Judge Gorsuch, and he says, "You need to talk to Jeff Lampkin." It was a name I kind of vaguely recognized but couldn't place immediately, but was a friend and former colleague of his. They had worked in private practice together some years earlier, and Jeff had just about a year earlier had launched his own firm with his partner Steve Molo Lampkin is the name of the firm, and turned out that Jeff had mentioned to the judge that he was looking for an associate because it was about a 5-person firm at that point, and I'm a little embarrassed, but Judge Gorsuch said, "We need to talk to Lucas Walker," and so I was like, actually he didn't connect right away, but we eventually touched base, and it's like, I really hadn't thought about going somewhere else. I thought I knew what firm I was going to go to, and this is a little new and a little scary. It's a place that's been around for, I don't know, probably 9 months at that point. What would it be like? But I decided, well, let's just see what this looks like. So I met with every lawyer there, all 7 of them at the time, and decided that, let's take a chance. It probably felt a little bit like taking a chance
Sure.
then, but as Judge Gorsuch put it, it's like, if the whole thing implodes in a year, you'll still be employable. And, but obviously it hasn't. The firm's still going really strong 15 years on. And, but yeah, I made the choice to go there, and it was really just the chance to work with really great lawyers. Jeff Lampkin's just one of the best appellate attorneys who's out there, argued at this point, I don't know, 27, 28 cases before the Supreme Court. And I always wanted to do, as I mentioned, appellate law. And so that's hard to get into. It's like it can be very hard to get into appellate practices at big law firms. And so this was a chance that just kind of came out of the blue to do really high-level appellate law right from the beginning of my career. And so it's like, this is the sort of thing, like, maybe I'd regret doing it. I haven't. But I knew that if I didn't do it, I would regret it. So I ended up making that leap and joined Muller Lampkin for the first time in 2010.
But that's not your only stop. I mean, you had a couple other diversions.
Yep.
Talk about them.
Yeah, so I practiced at Muller Lampkin for about 4.5 years, and during that time, after a couple of years, I decided to finally, pull the trigger and apply to clerk on the Supreme Court, which is like, that brass ring of clerkships for law students and young lawyers. And my grades were fine in law school, but they were not stellar. Good enough to get a great Court of Appeals clerkship, but I didn't really feel like Supreme Court kind of quality. I wasn't sure I really had a writing sample that I'd feel kind of like, was the right foot to put forward. But with encouragement, both from Jeff Lampkin and from then Judge Gorsuch, finally after a couple of years, like, all right, here's a brief that I worked on, and I could say this is like pretty much my own work product. This is something I can put forward. I've got these people who are supporting me. So I finally applied to clerk on the Supreme Court, and I got a call to interview with Justice Alito.
Again, mechanics, do they have like an Oscar type system, or is it really pinpoint? There's 9 justices, and I'd like that one, or.
If you could only afford to be so picky, so selective. Different people can do it different ways. There's no automated way of doing it. It's probably these days you email a lot of stuff. But back in those days, you put together a paper file, big manila envelope that had your resume and a writing sample and your transcripts and stuff like that. The recommendations would come separately. Traditionally, people will apply to all 9 justices.
Okay. Those 9 packages?
Yep, 9 packages. I had a great paralegal who really helped out in preparing all of those.
And your firm was supportive?
They were very supportive. Like I said, Jeff Lampkin, one of the partners I worked with the most, wrote a letter of recommendation. Maybe he just wanted me to leave. I don't know. No.
So.
But yeah, all really supportive, and then ended up getting that call interview with Justice Alito.
How does that work? I mean, does he do that, or does he?
The call came from his secretary.
Secretary comes, but you actually go in and have face-to-face with him, just you and him?
Yeah.
And without divulging any deep, dark confidences, but is it a normal conversation, or do you get into the detail of your depth of law understanding?
I'm sure it can vary a lot, but it was a little bit more, tell me about your practice and, kind of things you've worked on, and, kind of in that nature. It wasn't really deep. Now explain to me exactly what the requirements of the Rooker-Feldman doctrine are, or Pullman abstention, or anything like that. It wasn't a deep grilling into the intricacies of the law. It was just a great conversation about, legal career and aspirations and kind of the stuff that I was working on.
Do you ask about Yale Law School or Yale College?
I don't remember specifically. It was so long ago. It's very possible that he did.
Being a Yale,
he did mention his time. He mentioned his time at Yale Law, and I don't think I'm speaking out of school if I say he actually mentioned that he knew Fred Larson. When they were at Yale, and I think maybe also at Princeton together. And so we actually, and we spoke a little bit about Chautauqua, because Fred had spoken to him about Chautauqua, and that had stuck with Justice Alito about the things that we have here.
Yeah. I digress for a second. I was at the Supreme Court Historical Society event, and he was the speaker, talking about baseball. And so his wife was there, and we chatted at 5-10 minutes maybe about Chautauqua, about Fred, about coming here, because they want to just come vacation for a week and just hang. Of course, if you just don't hang, you take advantage of it as well. But it came pretty close to him coming here. Having dropped all the names you just dropped, including Fred. It was just a funny story. And plus baseball, who knew? So did you interview with anybody else?
I didn't. I got a nice letter from Justice Thomas saying thank you, but no. And I may have gotten some very polite rejection letters from others, but no, he's the only one I interviewed with. And I actually didn't get the job. He didn't. He didn't hire me for that year. But a year later, I got another call. Would you come back in for another interview? Oh yeah, of course I will. To clerk for him the next year, and that time he actually offered me made the offer during the interview, which was, and I of course said yes right on the spot. But that was great. That's a really fond memory.
So what was your conversation like with your wife? After you got done with the interview, what did you tell her?
I don't remember exactly how I broke it, but I'm sure I must have called her immediately afterward. It was a beautiful day, and maybe October or November. So I ended up walking back to the office because I was just kind of floating on air after that. So I'm sure I just called her and told her the news. But she was she was ecstatic. She was really happy for me to do that.
Now you get another judge's style. You got to kind of, they'd like you to draft in their voice. How'd you learn Alito's?
I think read a lot of his opinions before I started with him, kind of got a sense of it. A lot of it is like you don't sort of realize, he uses, this particular thing. It just, for a lot of it, just kind of internalize it, kind of in broad strokes. For me, it's just kind of the way that I learn, and so I think kind of got a sense for the way that he crafts opinion. I don't think I could tell you, this is the way that Alito's style is different from Gorsuch's style, but they're distinctive, and I think I was able to adapt pretty well to it. Obviously, both of them, have been judges now for a very long time. Justice Alito had been a judge for, I think, for 25 years by the time I clerked for him. In 2015, he'd been on the Supreme Court for about 9-10 years. So they know how they're doing it, but I think I did reasonably well in trying to provide good work product that he could do something with.
Did you go in and listen to the court arguments?
Yeah. There's a section in the Supreme Court courtroom where there's chairs on the side for the law clerks to sit and watch arguments. And so, again, as long as I didn't have something that I really needed to finish a bench memo or something like that for a case, I tried to go and watch as many arguments as I could that year.
Bench memos. I'm glad you brought that up. For the camera, is that designed to be kind of talking points for the justice as he's listened to oral arguments?
It can vary a lot with each justice and how detailed they want or kind of how they, what they want a bench memo to look like. But it's basically, here's a brief overview of the case, and here is how I think, taking into account like how the justice approaches the law, the case should come out. Applying kind of your, whether it's originalism, textualism. For other justices, it might be something more about living constitutionalism, or what's the purpose or the consequences of a particular decision. So taking those things into account, would be my recommendation for how you should decide this case. And, a chance to get into some of the deep stuff. It's like, well, they talk about these cases, but I actually follow these cases further down the line. And I think, maybe they tell us something different from what the parties are saying, or they reinforce it, or they give this little twist on it. Sometimes it's like, sometimes it's easy. It's like, this party is correct and this party is not correct. It could be clean cut, which is why a lot of the cases the Supreme Court decides are unanimous. They end up being, they're tough because they've divided lower court judges, but they end up, once they get up to the Supreme Court, becoming relatively easy for the justices to resolve. But other ones, it can be neither party is right in here. Actually, I think it's this third way is the right answer to this case, and just trying to give your best kind of honest, candid advice to the justice, and might agree, might not agree.
So you hand him a 10-page document, I'm guessing,
Yeah, that might be on the longer side.
Okay.
I said, Justice Scalia was very famous. He would only allow a one-page bench memo. He had, if you were one of his clerks, you would have to put everything on one page. I'm not sure if that was front and back or just the front of the paper, but that's still pretty tough to fit everything in there.
Just a few pages anyway, sort of like what I've got here. And you hand it to him. Does he comment on your bench memo? Does he mark it up, or is he saying, I get it, I'll use it or not use it?
It definitely wasn't a markup or anything like that, but, we would talk about it. All of the clerks and the justice would get together to talk about the cases before argument, and, he'd kind of give a sense of what he was feeling and reactions he might have had to the bench memo or not.
But then the argument actually occurs, and of course they have conference, which nobody's able to attend. And then does he meet with all four, is it four?
Four clerks, yeah.
Does he then meet with all four saying, hey, I just was in conference, here's how I voted, here's how I think, here's how I voted, and announcing whether or not he was going to write an opinion?
Yeah, so, you could do it a few different ways, but often, after conference, all the clerks would meet with the justice and get the lowdown of how they decided it. So on the Supreme Court, they wait a couple of days between the argument and the conference, so we have a chance to talk with the justice about how the argument went. And then they have the conference where it's just the 9 justices in there. And then, typically we'd get we learn, how the justice and the other justices voted on each of the cases that were up for that conference. The opinion assignments actually don't come out until later, and I don't think any of this is secret, but the assignments come down. So there's a 2-week sitting, so every month between October and April, the Supreme Court hears 2 weeks worth of arguments. And so on the Friday of the second week, the opinion assignments will come out, and the assignments are made by the most senior justice who's in the majority for any given case. So usually it's the Chief Justice who's the most senior in any case that he's in the majority in, and he's usually in the majority. Because most of the justices are usually in the majority, because a lot of cases are unanimous. But if it's not, if he's dissenting, then it would be Justice Thomas is the next most senior justice if he's in the majority, and so on down the line. And so that's when you learn what majority opinions that your justice is going to be working on out of that sitting.
And does that then translate, since you are the one, Lucas Walker gave me the bench memo on that case, and now I've been assigned 2 weeks later the writing of the majority opinion, help me with the draft? Is that
Typically, yeah.
That
If a justice gets 2 assignments and both of them were from the same clerk, and it doesn't make sense for that person to work on 2 of them, you could reallocate. Or if someone had gotten a whole bunch of majority, the clerk had been assigned to cases where the justice got a lot of majority opinions in a row, you might balance the work out. But typically, that's the way it would do, because that's the person who's going to be most familiar with the case among the clerks.
Now, that's the majority. Now, if Justice Alito had dissented, and now you can dissent, that's just it ends, I dissent. Or they could.
That's not common these days, but that sometimes happens.
Or they say, I'm going to write an opinion.
Yeah.
Is that the time at what point do you get a sense that there'll be a dissenting opinion?
Yeah, so, usually if the vote is not unanimous, one of the dissenting voting justices will write a dissent, and there's a lot of different ways that happens. You know, the most senior justice in the dissent might ask, you know, say, I'm going to write, or they might ask another one of their colleagues to write a dissent, or the lead dissent sometimes. But any justice can write a separate opinion, whether it's a dissent or a concurrence, that agrees with the result, or maybe even joins the majority opinion, but here's some additional views that the justice would like to do. And so they can do that whenever they want. There were a bunch of decisions that came out just a couple of days where I think there were about 4 or 5 different concurring opinions from different justices.
I find this fascinating, 'cause kind of the concurring, the dissenting, when they decide to actually write and not write. You know, that's because they don't have to.
Yeah, and
They could just join the majority, but normally it happened way down the process when they're kind of circulating opinions.
It can vary. You know, sometimes a justice is going to know, I'm going to write a dissent, or there is something I want to say that's not going to be in the majority, so, you know, let's start working on a concurrence. That can happen. Other times it might be, well, let's see what the majority has to say.
Yeah.
So there's, you know, and that can be for dissenting too. It can be, well, no, we're dissenting, so let's go ahead and get a start on it. Or maybe it's, well, we'll see what the majority has to say and what we need to respond to. So, but a lot of that's very just case specific.
During the year, do you have any time to yourself?
A little bit.
I mean, during the year of a clerkship, I mean.
Yeah. You know, it's a really busy year. My wife said, I never thought that I would see you less during your clerkship than when you were working at a law firm. But it is, you know, it is really intense. There's a lot to do, especially kind of toward May and June when there's so many, everything gets out by the end of June. They finish all of their opinions for the year by the end of June. So that's a real heavy time. But, you know, we do get time for ourselves, you know, weekends, after 10 o'clock at night. It wasn't usually that late, but you know, we would have time to do that, and a lot of time to be social with the other clerks. One great thing about the Supreme Court is that all the justices and so all the clerks are all in one building, and so you get to, and all the justices sit on all of the cases, and so you're all working on the same cases, as opposed to courts of appeals where the judges are in a whole bunch of different cities, and you're only hearing any case with 2 other judges. And so it was just a great chance to work with a whole bunch of other really talented, really smart young lawyers. Talk about the law, talk about the cases, but also talk about our families and our interests and things like that. And so we would have pretty regular social events, which were just a great chance to relax a little bit in a very hectic time.
And I know this is maybe a little unique, but did you ever have a chance while you're sitting there with all of these law clerks, assisting in decisions which are incredibly significant to the country, that you're a kid from Falconer, New York?
You know, I guess I still sometimes think about that as like, you know, came a long way. And, you know, a lot of people have there are lots of people who have not entirely dissimilar backgrounds, but there are other folks who, you know, went to, boarding schools, or they're from 3 or 4 generations of lawyers, or their parents clerked on the Supreme Court, stuff like that. Yeah. So it's like, wow, you know, but we all ended up in the same place. Yeah. And that's kind of the only thing that mattered then.
Among the clerks, I know you have that dining room and an opportunity. Do the justices join you at all? In the old days, because I've interviewed a lot of older clerks, 50s and 40s and 50s people, 50s time period, where every once in a while a justice would come in and meet with or talk to all of the clerks.
Every once in a while, you might have a justice stop by one of the social events. So, you know, clerks would, you know, have a weekly social event, and each chambers, they would rotate through the chambers as to which clerks were the ones kind of responsible for, you know, providing the food and stuff like that. And so you might get their justice for the clerks who were hosting to stop by. It didn't happen all that often, but that might happen. Well, one great tradition I hope it's still happening, but it was live and well when I was clerking, is that it's tradition for your co-clerks, the four of you who are for a particular justice, to take each of the other justices out to lunch. And so you get to spend a little bit of time kind of one-on-one or four-on-one with all the other justices on the
That's
court.
terrific, yeah. Well, was there any awe factor at all to you, or was this just kind of you're in the Supreme Court?
Yeah.
I mean, my God, most people can't get to a certain point, and you're in the inner sanctum. I mean, you are a room away from one of the 9 justices.
Yeah. Yeah. It's the sort of thing that if you think about it too hard, it can be kind of almost overwhelming. But you walk into that courtroom, or especially like late at night when you're working late and maybe just finished up and no one else is really around in the building, and you're walking through the great hall of the Supreme Court, this huge marble hall, or we're in the courtroom, and it's just like these phenomenal edifices, these beautiful structures where so much has happened. I'll confess, I think it was on the last night that I was there before I finally left at the end of my clerkship. I got up there in the courtroom, chamber of the court, and stood up at the lectern in front of the bench, and I don't remember exactly what I said, but delivered some argument or whatever, just
to John Marshall, right?
Yeah.
Marshall was the chief at the time.
The ghost of Chief Justice Marshall. Yeah. It's kind of one of those things. Just kind of pinch yourself. It's like, I can't believe that I've gotten to do this. Even today, I still think it's like, wow, I got to work at the Supreme Court.
Well, you weren't at the end. So at the end of Justice Alito's year, talk about the next step, which is equally kind of wild.
Yeah. So I went back to my firm for a little bit, and then it turned out that it's actually the very same day that I was promoted to partner, funnily enough. I got a call to an invitation to attend an event at the White House. So this was in January of 2017. And I had a sense of what it was, but they didn't actually say what it was. And obviously Justice Scalia had passed away during the year that I was clerking with Justice Alito, and that had remained vacant for about a year at that point. And so there was a question of what the new president, who he was going to appoint to fill this vacancy. There was a lot of speculation and everything, and just to cut to the chase, I got to the White House, and Judge Gorsuch was announced as the nominee to join the Supreme Court. Did
you kind of know as you were walking in?
Yeah, I mean, so it's like
the rumor mills go crazy. But.
Yeah, so when I got the call to come to an event at the White House, it's like it's got to be that. It can't be anything else. There's going to be the only thing that was in the back of my mind is, are there also clerks for this other judge who was being one of the candidates, and no one knows who it's going to be because they just invited everyone. But we were pretty sure that's what it was, and got there, saw a lot of friends, co-clerks who were there. So we had a sense before the official announcement, but that it was going to be Judge Gorsuch. But until he actually walked out, no one had told us for absolutely certain.
He was a big guy. I mean, tall.
Yeah. Yep.
So I mean, he commands a presence.
Yeah.
So he's announced, he goes through confirmation, it's always a rough thing, and I'm sure you followed it very closely, and it's probably, at times, probably somewhat painful, because you know him.
Yeah.
And there's people who don't know him are saying things. And did you have any emotional reaction for something very public, talking about people that you know? It's just... Yeah, and... and I guess a lot of you just have to realize that it's just the politics of it all, and it's just something that's going to happen, and people are going to try and look for anything they can. But I mean, the idea that Judge Gorsuch is some
heartless person who doesn't care about the people who, in the cases that he's deciding, is just so, miles away from who he is. He has to follow the law. If the law says, something, he has to follow it. You can't change that. You can't come to a different conclusion because of a sympathetic person. But the idea that, he or any of the judges, Justice Alito or any of the other judges out there aren't aware of those sorts of, how it can affect people, I think that's just unfair. But you have to realize that the judicial role is limited. They have to follow what the law is, their best views of the law, and they can't change that in a particular case just to, have the little guy win. Little guy won plenty of times with Judge Gorsuch and
Sure.
now Justice Gorsuch, but that's because the law said that he had to, not because that's what he wanted to happen, or, they didn't lose because he didn't want it to happen.
He gets confirmed. Now he's got to fill a staff.
Yeah.
How do you factor in that?
He just very graciously called me and asked me if I'd come to clerk for him for starting with the first full term that he'd be on the court. So he was appointed in April, and then in July the new term would start. So he asked me to be part of that class of clerks, and that's a great memory too. I think he framed it as, "Would you do me a favor?" But obviously, it was the honor was mine to do it. It felt a real privilege to go back and do what I think is the best job you can have in the law, to clerk on the Supreme Court, and to do it for someone I'd known at that point for almost 10 years, that I had so much respect for, and that he thought he had a lot of choices, and that he thought that I was one of the folks that he wanted to help him out. That first full term on the court was really touching, real honor.
Did he do that with others? Did he kind of pull together an all-star cast?
Yeah. So all of his clerks. So he had a group of clerks who joined him right at the beginning, right there in April, to finish out the term that had a few months in it still. So all of them were former clerks of his, and then a couple of them stayed on, and another former clerk of his joined. So all four of us who were there that first full year of 2017 to 2018 were former clerks of him, and that was just another great part of it, because we all knew each other from a long time as being part of the Gorsuch clerk family, and we had worked together to help with the confirmation in different ways, so we got to know each other better that way. And three of us had already clerked on the Supreme Court. The other two of the others had clerked for Justice Scalia previously, and the fourth of us was one that had started in April, so he had been there for several months, and so we all knew kind of how the court worked when we were getting there, and we were working with someone a justice that we knew so well already. So it was a really unique and wonderful experience to come back to the court and do that familiar job, but in a kind of a very different context.
You mentioned the confirmation, without belying any confidences. What does one do to help? Did you kind of remind him or bench brief him on maybe an issue that may come up? Is there a sense of that?
So this is all public record. We actually did some appearances on local television and radio in some states where I thought it would be helpful to get the attention of some senators. So there were a group of us that did some of those things, and then some other things. I was not very deeply involved in it, but had opportunities to help in little ways to
Spread the good word.
Yeah, and some other ways to help prepare for the confirmation hearings. But that was other people did so much more. I had just a very tiny role in any of that.
So now you're back on the clerk, or back in the court. Did his style were there any changes from his style as a 10th Circuit Court of Appeals judge and a Supreme Court justice in the inner workings of the clerkships? I mean, did you find that what you did there, you did here, and so it was easy for you, or were there any kind of changes in protocol or procedures?
I think it was largely the same. We did, bench memos before arguments. If we got an opinion assignment, we do the first draft of it and work with the co-clerks, go back and forth with the justice with that. So all that was all pretty similar. The one thing that is a little different is that on the Supreme Court, they have an almost entirely discretionary docket. They get to choose what cases they're going to hear, with some very small exceptions.
Yeah.
And so the cert process, so the way you ask the Supreme Court to hear a case is you file a petition for a writ of certiorari, or a cert petition. And so they get about, I think these days it's somewhere in the 5,000s. I think it was probably in the 7,000s back when I was clerking. 7,000 petitions asking the court to hear their cases. And so that's a big part of being at the Supreme Court, clerking at the Supreme Court, because you don't have the lower courts, because they have to hear basically every case that comes to them. And so, we had to figure out what the right way to deal with the cert petitions and figure out which ones the justice should vote to hear. So that was a little new piece of it, and he made this decision before I got there. But at the court, there's a thing called the cert pool, and so the justices who are in the cert pool, their clerks kind of collectively will divvy up all of the cert petitions, and so they'll each get a few each week, each time they distribute the petitions, and they'll write up a memo according to a pretty specific form. There are old cert memos that have gotten out there from archives. Actually, I think from the Gorsuch confirmation, you can even find some of the pool memos that he wrote when he was a law clerk on the Supreme Court. But it's a recommendation to all of the justices who are in the cert pool on that. And so 7 of the justices are part of the cert pool, so their clerks, write those memos. They get written up for every single petition. But 2 of them are not, and they're Justice Alito and they're Justice Gorsuch.
No kidding.
So he decided early on when he joined the court that he would stay out of the cert pool and have his chambers, the 4 clerks look through all 7,000 of those petitions, in chambers instead of splitting them up. And there's advantages to both of those. I'm partial to the not being in the cert pool because it's what I did with both of my justices. But obviously there is an advantage to making sure that there's kind of a memo that follows a particular form for every single petition that comes in. Make sure that everyone is heard. But yeah, we look through among the 4 of us, we looked through all 7,000 of those petitions.
Wow. I can't imagine just the workload of that process is
extensive. Yeah, after a while, you get your process down, you get your routine down, you get a good sense of what are good candidates and less promising candidates. So, but it does take some time. It's actually nice that the clerks turn over in the summer, which is almost 2-3 months before they start hearing arguments. So the only thing to do is to go through the cert petitions, and so you get a good learning curve to figure out how to do that, become more efficient before you add on the merits cases, the ones that are being argued before the court.
Another just a mountain of curious questions, but did you, and this could apply to any justice, I don't want to be Gorsuch specific, but where they had a view, a justice you kind of knew, had a view going into the case. They talked to their clerks, and you had a sense, talking among the clerks, kind of maybe where their boss was. And then after the conference, they come out and sort of have a different view.
Yeah.
I mean, so just curious if that...
Yeah, that sort of thing can happen. I would say most of the time the justices have a sense before they go into argument how they think they're going to vote on the case. And the argument rarely changes someone from, reversing to affirming or something like that. Like if they have a preset view, it's rare for the argument to do that. They famously say that you're more likely to lose your case at argument than to win it at argument. So the goal for the advocates is to sort of like take on the least water, lose the least ground as you can, because the questioning can be very intense. But in close cases where they might not be decided, that can kind of sway things. And then when they talk at the conference among themselves, the justices can give their perspectives, and that's they can get a sense from each other at the argument where other justices might be coming from, but when they're actually at the conference, that's usually the first time that they're actually talking among themselves about what they think of the case. And so if someone has a different perspective, it's like, I don't think either party is quite right, and this is the way I would do it. Those sorts of things. And I actually have no specific case in mind. This is just generally speaking, where, that can lead to different outcomes, and, sometimes there can be surprises that come out of that.
They talk about, and it's just a one-case deal, I believe, on Brown versus Board of Education, that Baird Prettyman and the other clerks had no idea where it was coming out. And so they literally learned it when the decision was read. I mean, that's kind of the secrecy of that one case. Was there anything quite like that during your time period?
I don't think so. And this is all pretty publicly known. There's a process where the draft opinions are circulated, the justices join them, and so the clerks are going to have a sense of what opinions are being proposed and which justices have joined them or are writing separately. So there might be some surprises along the way, but by the time something's ready to be announced, everyone knew it was coming. Yeah.
Curious about your term comes up with Justice Gorsuch. Well, let's back up one second, because I need to know this. I need to know this. Gorsuch followed Scalia. Scalia followed Rehnquist. Rehnquist followed Harlan, John Marshall Harlan, who in turn followed Robert Jackson. So in the chronological sequence of seats, seats of the court, not everybody understands that, but the seat of the court, it's Jackson to your guy Gorsuch.
Yep.
Any reason that ever came up?
I am sure I mentioned it. Justice Gorsuch signed one of the books for the center here, and I believe it says that he's proud to occupy the seat that Justice Jackson did. But I'm sure I mentioned it to him probably pretty early on, and I think it's a neat, because that's a great lineage.
Yeah.
Jackson, Harlan, Rehnquist, Scalia, Gorsuch. I think that's really terrific. Seat 9, I believe it is.
Is that what it is?
Yeah.
Well, Jackson's actual chair is right out here. And if we didn't have one in the past, we'll do it today. Make sure we have a picture of you in the seat, so you can send it to him. Say, someday maybe you'll come and sit in it as well. Yeah. Again, now we're on Jackson, and I forgot to even ask about it, but as you were going through law school, did Jackson come up much at all?
Yeah. I would say in law school, two of his opinions, or you see a lot of, there are his concurrence in the Youngstown steel case, where he sets out kind of a three-part framework, is maybe even a little bit specific for it, but saying, a way of thinking about presidential power. When president and the Congress agree on something, his powers are disgraced, because he's got everything that he's inherently got under the Constitution and everything that Congress constitutionally could give to him. And then you have this other end of the spectrum where Congress has said he can't do something, and the president is saying, well, I have a constitutional authority to do it. And that's kind of the hardest part, because it's really only what the Constitution gives to him, and Congress cannot ever take away in any way or control. And then there's that zone of twilight in the middle where Congress may not have had said something, and trying to just providing a way of thinking about it. And I think some people have criticized it as not being especially helpful in deciding cases. I don't think it was ever really meant to be, this is the way we decide the cases, you fall into this category, therefore, X wins or Y wins. But I think it's one of those things where it's just kind of helpful to put things into words, these concepts that might be a little impressionistic, and sort of start thinking about it in that way. Why what are these dynamics in terms of how the president and Congress interact with each other. And so that's one of the, the kind of the canon opinions. It's probably, in terms of concurring opinions, like that aren't opinions for the court, it is probably one of the most famous in constitutional law that you see come up again and again. I mentioned, I took all those separation of powers classes, and that was one of the staples of those cases in terms of a concurrent opinion. So that's one that definitely came up. And then his dissent in Korematsu, where the majority of the court upheld Japanese internment during World War II, and Justice Jackson dissented and saying, this is wrong, this is legally, this is unconstitutional, and having this decision, I think he said, it's going to be laying around like a loaded gun for someone to pick up later. You might think you're doing the right thing by supporting FDR and not interfering with the war effort, but having this thing on the books is going to be dangerous later on. And I think that imagery of that loaded gun, I think, is something that really struck people. And Korematsu is viewed as one of those great stains on the history of the court, and so his role in speaking out against that is something that definitely came up.
When Fred Korematsu accepted our invitation in 2002 to come here, and the reason he accepted, he was a frail guy, but he came out with friends and his wife. But he said, the reason I came was because I felt Jackson was my lawyer. That was an interesting comment. Not a judge, my lawyer. Just because of the words he used and the dissent. You can see that on YouTube. Yeah. Okay. During the Gorsuch term, which was sort of a special deal because you were invited by him. My God, it's not like you asked to be accepted; you were invited. Do you feel that even now that you have sort of a special relationship with him?
Yeah, I think so. I think it's as well with Justice Alito, but the fact that we just know each other for so long, yeah, still someone I look to for advice. Don't see him as much as I'd like to, but love all those opportunities, and really appreciate all the support, mentorship over the years.
You leave the court and then go back to Molo Lemkin, LLP, and but you're going to be in the appellate practice. Then that's kind of really hard to do. Famously, John Roberts, Chief Justice, working for Hogan and Hartson, got into the appellate practice under E. Barrett Prettyman Jr., who was on our board and was the last law clerk of Robert Jackson. So it kind of gets wonderfully incestuous, but all of a sudden, always when Barrett Prettyman would come here, he would always have the front page of one of the petitions, and there at the top, where they have the not a jurat, but where they have the listing of the attorneys for the petitioner, always there'd be E. Barrett Prettyman Jr. to list those who worked on the case, including at the bottom John Roberts. So he always loved showing that, type of thing. I'm an appellate, and he argued at the time. He said, 21 some cases, and it makes for a fascinating interview. But he also talked about his very first case, where he had left the court, having clerked for 3, justices of the Supreme Court. But his reaction, without telling you what his action was, I'm curious about yours, because you argued a case before the Supreme Court.
I did, yeah. About last year, March of 2023. The case was Abitron, Austria versus Hetronic International. And it involved whether U.S. trademark law applies outside of the United States, whether it's extraterritorial. And so that's a case that came to us as a cert petition. We were asked to do a cert petition challenging a Court of Appeals decision that had upheld about a $100 million damages judgment against our clients who had for infringing the plaintiff's trademark, but almost all of the infringing sales, more than 99% of them, had happened in foreign countries like Germany and Austria. And almost none of them were in the United States. And so, but courts of appeals for 70 years had said that the U.S. trademark law, the Lanham Act is what it's called, applies extraterritorially. And so it can reach sales that are being made outside of the United States if they have enough of an effect on the United States. And the courts had kind of disagreed about what the test was, but all of them had agreed that, yep, the statute is extraterritorial. Now we just need to figure out when it is. When does it apply to conduct outside of the United States? And so we put together a cert petition saying, look, the lower courts are really divided over, how this law should be applied, and frankly, we don't think it should ever be extraterritorial. Kind of added, like, we disagree with all the courts of appeals, but the fact is the courts of appeals disagree even insofar as they agree that it should sometimes apply outside of the United States. And so that's they call it a circuit split or a circuit conflict when the federal courts of appeals disagree on some question of federal law. And that's kind of the traditional time when the Supreme Court is going to hear a case to resolve those sorts of splits and bring uniformity to federal law, which is supposed to be the same throughout the entire country. So we did the cert petition, and then the court did what's called a CVSG. That's a call for the views of the Solicitor General. So the Solicitor General, which Robert Jackson was back in the 30s and then into the 40s. I don't remember exactly the years. I know Frankfurter thought he should have been the Solicitor General for life, argued some 30 cases there. So the Solicitor General is the United States government lawyer for the Supreme Court. The Solicitor General's office, some very small exceptions, argues all of the cases where the United States government or any of its agencies is participating in a case before the Supreme Court. And so what the court will often do is call for the views of the Solicitor General to get the perspective of the United States as to whether a petition that they're considering should be granted, whether this is an issue that warrants the court's attention, and whether this particular case is a good, they call it a good vehicle or a case for the court to decide that issue. And so we met with the Solicitor General's office as part of that, explained to them why we thought that this issue was an important one that the court should take up, why we thought the decision below was wrong, which isn't the most important thing right at that stage, but is, plays into whether the court should take a case, and why we thought that our case was the right one for the court to resolve this issue. And we got very fortunately, the Solicitor General's office recommended that the court grant our petition, and it did a few weeks later, in November of 2022. And then we were very quickly on the clock to write our briefs. We actually fell into a time of the year where you can't really get extensions because you need to be able to hear the case before the court adjourns for the summer. And so I think we got the cert grant. They agreed to hear the case on about November 4th. And we had to file our brief around December 19th. So we got 40 days to write a merits brief to the Supreme Court, asking it to rule in our favor, and to, our main argument was to tell the court that all of these courts of appeals have been getting it wrong, and this statute, this trademark law, never should apply outside of the United States. It's never extraterritorial. Sometime in there, I was lucky that the client was willing to have me argue the case when it actually came up for argument at the Supreme Court.
Were you nervous?
Yeah. I mean, so the briefs were the hardest ones I think I've ever had to write, just, when you're at that stage and you're getting to a really difficult area. And then the preparing for argument is intense. So we always do multiple moot courts, mocks, to prepare advocates for any oral argument. For this one, I think I did 3 different ones, and basically had people bring out the knives, be as tough as you can, because the justices, it's a very hot bench. They ask a lot of questions at arguments, and they can come from all sorts of directions. So you want to be prepared for it. Ideally, you'll get to argument, and you're not going to get a single question that you haven't already heard in some form during one of your moot courts. Did that, many with my colleagues, a lot of really talented lawyers at our firm who love to bring the knives out for moot courts. Had a former co-clerk of mine who joined one of the moots, and I was also lucky enough to do the Supreme Court Institute at Georgetown Law School. Yeah, so they hold a moot court for ideally every single merits case that the court hears argument in any given year, and they bring in just ringers, just like great appellate experienced attorneys to be your panel of the mock Supreme Court. They've got their courtroom is set up basically to look a lot like a smaller scale version of the Supreme Court courtroom. The lectern is just as far from their bench as it is at the Supreme Court, and so I think it's a coin flip or something like that as to which side of a case gets to argue at the Georgetown moot. But I got to do it. That was incredibly helpful, but also like really draining, because it goes on for hour or 2 hours to kind of be on that whole time and be fielding a lot of really difficult questions. But through that whole process, it just really helped to get prepared, get comfortable standing up there. I'd argued other cases before, but none in the Supreme Court. And so I felt like by the time it came for the argument, you always wish you could be more prepared, but I felt like I had done the things that I needed to do to be ready for that. In addition to just the moot courts, just went through all the questions that I thought I could get, working out what I think the best answers are, refining them, honing them, getting them as short as possible, because you don't know if you're going to get more than a few seconds to answer any question at the court before another justice asks another question. So it was, it was nervous. I think I was the most nervous the night before, where I kind of like really felt as like, okay, wow, it's really all coming to this. Here it is. And then the next day I got like really early. So the court starts at hearing arguments at 10 a.m. and I probably woke up about 5 or 5:30. And so by the time it got to the court, it's like, all right, I've had just a chance for the nerves to dissipate a little bit. Had my 1 cup of coffee, but it had worn off a little bit, so I wasn't too over-caffeinated. And so it wasn't exactly zen, but I think I was pretty calm. Said a prayer as waiting for everything to begin, and I think that all really helped. And so by the time he got to stand up there and say, "Mr. Chief Justice, and may it please the court," I felt like I was in a good place.
During the Abitron case argument, were there questions that had not been posed that kind of like, they got me? Not to gotcha, but I didn't prepare for that.
Yeah, no, I don't think there was anything like that. They were all sort of, in the more or less in the vein of what I had expected or heard before, was prepared for. There was some that came from a little bit of a different angle. Justice Jackson, actually, I think she asked all 3 of the advocates, because it was me, the party on the other side of the government was also arguing. A set of hypotheticals, like sort of 3 different situations involving a German handbag maker making knockoff Coach handbags, and if in this situation, what would your answers be? And so that was, because I knew what my principles were, I knew what the principles of the rule we were asking the court to adopt were. I was able to, on the fly, figure out, okay, running your facts through those. Here is the answer in this situation. Here is the answer in this situation. Here is the answer in this situation. And so it was, I didn't have a question that was specifically about U.S. college students buying handbags in Germany and selling them at a garage sale in the United States, but because I knew what my position was and what was underlying it, I was able to adapt and respond to that hypothetical.
Having had much experience, did you kind of know which justice would be more hot than others?
There are some justices do tend to be more active at the arguments than others. So, Justice Thomas kind of famously, for a long time, didn't ask any questions or arguments. I think to everyone's benefit. Over the last few years, starting when they were doing the telephone arguments during COVID, he traditionally now asks the first question of each advocate. And so you always get a question for him, but it's usually just a couple of questions. And so kind of knew that's probably what I should expect to begin with, and had a few there, and then it moved on, and then there were others who were more active. I think I got questions from a few others, but Justice Sotomayor, Justice Jackson, and Justice Kagan were probably the ones who were most active during my time up there. Justice Alito, I know, was Justice Gorsuch were a little bit more active when some of the other advocates were up there.
You know, you read so much about, sometimes the questions are really a question they ask you, but they're really looking for an answer to help another justice. I mean, it's sort of that, you know, you're just the intermediary to leave a message down here. Any sense of that?
I think, I mean, that definitely does happen. I don't remember any questions where it felt like that was happening while I was up there, although certainly you could tell there were some points where justice who probably knew where they knew where they were coming out would bring up some particularly what they thought was a particularly important point or piece of evidence or, you know, legal authority. And so you'd get that coming out, and sometimes it might just be to challenge the advocate on that side, but it also might be to remind their colleagues of, you know, that part of the case as well.
Abitron has been recognized, I know this is the firm's puff piece, but Abitron has been recognized as a landmark extraterritoriality decision with broad implications for transnational litigation.
Yeah.
Do you believe that?
Yeah, I think it's right. It brought a lot of clarity to what the rules are for extraterritoriality, and most importantly, so there's two parts of extraterritoriality. Not to get too into the weeds, but the first is step one: is this law extraterritorial, which requires a very clear statement from Congress that says it applies outside of the United States. If you have that clear statement, it's very rare, but sometimes it says it applies outside the United States. Then you just follow the rules and it applies in the circumstances the statute has. If it doesn't, as almost all laws are not going to have that clear statement that they apply extraterritorially, then there's this step two question as to what is a extraterritorial, therefore impermissible, versus a domestic and therefore permissible application of this law. And that actually was the really big divide ultimately in this case. So the plaintiff argued the law should be extraterritorial, and you know, they should get the recovery that they wanted there. But the government agreed with us that it was not extraterritorial. There wasn't that clear statement that's needed for it to apply outside the United States. But we disagreed, we and the government disagreed as to what it means to have a domestic application of this law. And so we said that the use of the trademark has to happen in the United States. And the government said it's okay if the trademark was used outside the United States. You know, you made sales in a foreign country, as long as there is a risk of consumer confusion within the United States, because their view was consumer confusion is what the statute is really concerned about. And so as long as that's happened in the United States, that should be enough to call it domestic. And with the court and so the decision of the court, so we won, I guess I should say that part of it. We won, the court unanimously 9-0 said it's not extraterritorial.
Really?
Yeah, but it divided 5-4 as to what it means to apply it domestically. So this really was ended up being the central issue there. And so 5 justices, with Justice Alito writing the majority opinion and joined by Justice Gorsuch, Justice Jackson, who would ask me all those tough questions, hypotheticals, Justice Thomas and Justice Kavanaugh, they held that for a domestic application of a U.S. law that isn't extraterritorial, the conduct has to happen in the United States, and specifically the conduct that's relative to the focus of the statute. And here they didn't have to decide exactly what the focus of this is, but they decided what the conduct, you know, whatever it is, even if the focus is consumer confusion, the conduct that's relevant to that is going to be that use of the trademark, because that's the thing that the statute prohibits. And so they agreed with us, those 5 justices, that a domestic application requires the trademark to have been used in the United States. And so that was great. That was exactly what our position was. We were delighted to have that. And then the other 4 justices, Justice Sotomayor writing a concurrence in the judgment, is what it was called, and joined by Justice Kagan, the Chief Justice, and Justice Barrett. Unusual lineup on both sides, which actually it's not that unusual. Those sorts of groupings happen a lot, but I don't think that gets a lot of play. People don't notice that as much. But they thought that they agreed with the government's position that as long as there was confusion in the United States, that should be enough for a domestic application. So now we have a really clear rule. Where is the conduct to happen?
Yeah. And you just saved these guys $90 million, damaged children.
Hopefully at the end of the day, that's what it is. We're still finishing everything up in the district court, but it looks like it's going to be something like that is going to be the reduction in the amount.
So your practice is, I don't want to say niche, but it sounds like it is. Appellate division, appellate arguments for, I assume, the federal courts and federal court systems, right?
Yeah, essentially covers it, yeah.
You don't do state courts or anything like that, do you?
Every once in a while, but our focus is on federal appellate courts. And I should say that that's my personal practice, but the firm does practice much more broadly than that. They're in New York state courts, commercial courts, quite a lot, including appellate courts, and trial courts all over the country. So we do a lot of things, but in terms of my personal practice, it's mostly federal appellate courts.
For those who wonder or listening to this, this has been an amazing conversation with Lucas Walker, because it's nigh on to 2 hours, because you're curious, because I'm hearing the sounds, the bells, the angelic bells of the church across the street here, which obviously says something special about you, as we raise you to special level. You knew you were coming in here, whether you wanted to or not, but you're here coming to be interviewed. Was there a question or two you thought you might be asked but hasn't?
Not that comes to mind. I did suspect the teacher's question was going to come up. You gave that some thought. I don't think so.
Well, that's probably being the advocate that you are. I was curious. You graduated from Falconer High School and probably achieved more at your young age than probably anybody ever from Falconer. And I'm making that statement, not you. But nevertheless, is there sort of a message if you were given the commencement address to Falconer High School, that you might say, here's the bottom line, here's the conclusion?
Oh gosh, don't be afraid to try for things that you dream of. I mean, I don't think any of the things that I was lucky enough to do in my life, none of it was a guarantee. Maybe none of them were really even likely to happen. And so a lot of it is, kind of luck. Be prepared, do the best you can, put yourself in that best situation, but don't be afraid of something just because you're not sure it's going to work out, because sometimes it will. And I think all the things along my way, going to college, going to law school, the clerkships that I got, the practice that I stumbled into based on a chance interaction at a conference, all those things are not exactly the things you plan for or that you could ever make as part of your firm plan. I think be open to that, put yourself in the best position to it, and put yourself out there and try.
Well, that's one of the points to make, is you put yourself out there and try, because if you're not out there, you're not going to be in the game.
Yeah.
And you've always done that, and yes, but you got a tremendous skill set to make that a reality.
And something doesn't work out, like that's not the end of it. I had a great clerkship and I lost it before I even started, right? And it turned out I ended up clerking for a judge who later ended up on the Supreme Court. Like, that's just, it's not anything you could plan for. It's just complete not complete luck, but, a lot of happenstance. And so, sometimes, I think things usually happen for a reason, and, something seems like a setback at one point, then, maybe it's because you needed to have some path adjustment that's going to lead you to the place where you need to be.
Well, I'm just thrilled you took some time here, Lucas, to come to the Robert H. Jackson Center and to, I know you've been connected with us in many forms and manner, and we hope to have that continue to be so.
Oh, my pleasure, Greg. Really happy to be here, and thanks for having me.
And the most tangible thing we're going to do is have you sit in Jackson's chair, which will then continue the lineage.
Great. Thank you.
Thank you. Appreciate it. It's been great.
Yeah, thank you.
It was fantastic. And